We're going to be talking about up north properties today. So welcome. I'm attorney Peter Harbach.
And I'm Sarah Cons.
And we're from Hooper Law Office. And hopefully you guys are all here to listen about how to do estate planning with family property, cabins, cottages, and no matter what type of property is, it's property up north, even if it's down south.
Yes, in Wisconsin, it's always up north. There are a couple of handouts that we're going to be providing the attendees. We have some common types of business structures. So what is the difference between a partnership and an LLC? What are some of the properties of different types of entities that you might use in order to own this? And then we've also got a list of common tools that are used to manage or pass on properties that you might have up north: cabins, cottages, hunting land, farmland that you might rent out. I mean, there's a variety of different types of property that we're talking about. When we're referring to up north property, it kind of encompasses all of these things.
Yeah, so as always, we have a way to see if you have questions. So if you're on Zoom or Facebook Live, if you post questions to us, we're going to have a little Q&A at the end of this. Also, you have to have been registered through Zoom, I believe, in order to get the materials that you were just showing.
In order to submit questions as well.
So, well, let's just get started. So again, this is on family cabin planning, and the starting point for this kind of planning is, what is your current estate plan? Because that's how the thing is going to pass on if anything happens to you. So the good starting point is know what you presently have. Is your plan a will, or is it a trust, or do you have transfer on death designations on deeds to property? Know what it is that you have. And then also, it's a good idea to start also with, well, how does this stuff actually work? How is my plan going to function? Because I've encountered, and I'm sure you have as well, a lot of estate plans where the expectation of how this thing works is very different than the function of how it'll actually work. And so digging into your own estate plan a little bit to really understand, okay, how does this thing function, is going to be important, because you might have great terms for your up north property in, say, your will. But if you put a TOD designation on the deed, well, then it's transferring, and none of those terms in the will are going to mean anything.
Right. A transfer on death designation is what TOD stands for.
Yeah. So start with, okay, what are your estate plan documents actually doing right now? And then think about, well, what are your actual goals? You can't get somewhere if you don't know where the heck you're trying to get to. So what are you trying to accomplish for the property or the family? Is it something where it's a great priority for you to keep this as sort of family legacy property, so it's going to go down throughout multiple generations? Is it, boy, I'm worried about making sure the family cabin isn't gobbled up by nursing home expenses. I want to set things up so that the kids are able to continue to use the property in the easiest possible manner. Basically, you got to set your goals so that you can start to figure out, okay, what are we going to use to accomplish these goals?
And then you also want to consider the circumstances of the people that you're leaving this to. Is this something that, if it's property that you want to pass on, are we leaving it to people that are able to do that they're able to maintain it, the financial requirements, things like that? And are there things we should adjust about the planning in order to accommodate some of the individual circumstances of the beneficiaries that you have in mind?
Yeah. So once you've kind of set your goals, you also want to be a little bit realistic about it. I've had a number of people who, because the up north property is very important to them, they have a strong tie to it. They start out the conversation with, boy, I want this to go to my kids. But then we talk about the kids' circumstances and come to realize that the kids don't actually want the property. So I'd encourage you to take that into account. Does anybody actually want to, live in, maintain, use, any of those things? This property that's, yes, it's important to you, but is it important to them? Because otherwise you're kind of spinning your wheels. Oh, I'm setting up this thing because it's important to me. And you put in the time and effort and pay for getting everything set up in a manner that you think, oh, this is what I want. But if it's not what anybody else wants or everybody else wants, it's not necessarily going to function all that well, despite your best efforts. So it's important to just think realistically. Do these people actually want this property?
Mm-hmm. Once you've been able to establish whether or not the people that you intend to leave it to want to continue to own it, you can start looking at more specifically the individual circumstances. If there are people that don't want to necessarily own it, are you passing it to them so their ownership can be transitioned to another child? Are they buying each other out? Or is this something where you're trying to allocate it to only those that want part of it? Are you expecting them to be balanced out in some way through your planning to ensure that everybody's still treated equally,
or not?
Or not?
I mean, that raises a great point. If this up north property is worth $200,000 and you have 4 kids, and absolutely one of them is never going to use it, doesn't want to use it, they live in Kentucky and don't come back to Wisconsin all that much. Well, then, is it that you're leaving the property to the other 3 kids? And if so, is there any kind of, are you giving additional money to the one in Kentucky so that everybody's total share of everything is equal? Or is it, okay, since you don't want that property, we'll split everything else up equally, but then that property is just going to these 3?
Or is it something where they're buying that share out over time? So there's an agreement among the other 3 kids to purchase that share over a period of time. Or, fair and equal are not always the same thing. And that's definitely a concept that we end up talking through with our clients on a regular basis. If there is somebody that, for example, has been very involved in maintaining the property, that they're going up every spring to cut the grass and deal with whatever winter has created over this property, any updates or any repairs that have to be made, if they've helped with maybe some of the financial aspects of it in terms of putting on a new roof or insurance or some of the basic maintenance, that these are things that maybe this person has contributed time or effort or basically sweat equity. So therefore, in your mind, it might not be necessary to equalize this out or balance it out with other assets, because maybe you have 2 kids. One of them has been very involved in the use and the ongoing maintenance of this property over the course of the last 10, 20 years. And the other one hasn't, because they're just not interested in it. It just isn't something that they have participated in that way. It might not be necessary to do that offsetting payment or that balancing. It's based on what has happened in your circumstances and what you believe each of the beneficiaries you're including really needs to get out of your planning.
Yeah, and then the individual circumstances of these people, assuming you want them and or they want to own this thing, take into account. Can they afford it? If the expectation is, hey, I want to keep this family cabin going down multiple generations, well, you got a couple of kids and one of them's not maybe doing so great financially and the other one's maybe fine. Is this just going to be a financial burden on the one that isn't doing so hot financially? Can they afford to maintain a second property that has property taxes and insurance and utilities and some amount of maintenance? You certainly will have discovered over the years that owning property isn't free. And so can the kids afford to maintain this thing? And are they in a position to maintain it? As Sarah was describing, you got one kid who maybe over a bunch of years has come up and is using or at least maintaining that property. Maybe that's because they're the only kid who lives anywhere nearby. Mm-hmm. And are you is everybody collectively looking to be sort of absentee landlords on this thing? Is it important enough for them? If nobody lives in the state, and the idea is, oh, the family cabin would be a nice spot for them to all come back to. There's nothing wrong with that idea. It's a very nice idea. Again, just the practical side of, okay, we've got all absentee landlords. How are they going to coordinate the ongoing maintenance expenses, all of those sorts of things?
You also want to consider the liability side of it. If there are a lot of the potential beneficiaries that live in other states, owning property can be a liability, that if anything happens on that property, then there could potentially be liability on the side of the owner, even if that owner is not somebody that regularly participates in that property. It can still be a liability for them. So there might be reasons for them to not want to be an owner if they're not continuing to use it. A good guideline that I tend to recommend to my clients is think about how it's being used now. If you are regularly seeing the family come together on this property, you spend, a couple weeks there in the summer, or that's where you have Christmas, or it's sort of a constant in your family, and there's continued participation from the people that you want to include, then I think it's realistic that after you're gone, they're going to want to continue that on their own. If it's not currently being used that way, I don't think it's realistic to then expect that there's going to be the sudden change and all of a sudden they're going to start using it as a gathering place. So it's, again, good intentions, but what is the current situation, and use that to help you make some decisions. When you've been able to evaluate your situation, what it is that you want, what it is that the people that you're expecting to participate in this, what they want, then you can start looking at, okay, I've made the decision that I want to pass on this property to one or more individuals. Now, how should I go about doing that? What is the best mechanism or document or method in order to do this?
And one thing you're going to take into account in making those types of decisions may be, well, how many people are going to be owning and using this? Because obviously, if you're looking for a large family to co-own this, you can kind of get in a position of, boy, we got kind of too many chefs in the kitchen, too many decision makers simultaneously, each with their own ideas, thoughts, preferences, budgets, etc. So how are we going to make sure that we have a system in place for, the inevitable argument? How are we going to resolve these kinds of things? Because the purpose of the family cabin or cottage is to bring everybody together. It certainly doesn't work if owning it is tearing everybody apart. And that can just frankly happen if there's not some kind of system in place here.
You have to remember that your kids can accept decisions from you. It's harder for them to, after you're gone, accept decisions from each other. So that's why having a plan and giving them direction on what they should be doing really becomes invaluable in maintaining the cohesiveness of your family, that piece of property is actually bringing them together rather than creating a wedge between them.
Sure. And so some of the decisions, how do we determine use on this property? Meaning, if maybe there's 2 bedrooms in there, and there's 3 families that are using it, how do they determine who gets it on which weeks or weekends? Who gets it over the 4th of July? Who gets it over Memorial Day weekend? Things like that. So determining use and having a system in place to choose whether it's sort of a rotating week thing or a round robin, you get to pick, I get to pick kind of system. That's going to be determined at least in part by the number of potential people that are going to be using this thing. Obviously, you have to get a little bit more in depth with a larger group of co-owners or families that will be using this thing.
It isn't necessarily that you have to determine all of these things in advance. what you're trying to do, what you are trying to do is give them a method for figuring this out later that is easy for them to use and that everybody understands that that's how they're going to go about doing it. It's not necessarily making the decision early, it's making sure they understand how the decision will be made by the group later.
Create the system for them to use. Then also expenses. How are expenses going to be paid for this property? We kind of briefly mentioned earlier, not all the kids are necessarily in the exact same financial situation. Some might have, more ongoing expenses and liabilities, lots of kids of their own, things like that. Whereas others might have, quite a bit of free money, that's sitting in their bank accounts that they can allocate towards different things. And so that might make a determination on, okay, boy, I want to put in a new roof, or I want to upgrade the bathrooms, or put in a new dock, or whatever it might be, stuff that costs money. Hey, if we're going to do this, you use it too, so we're splitting the cost on it. Well, wait a minute, I can't afford that. I've got 6 kids and make half as much as you. How are we going to create the system to make sure that this is going to function? Because even if one side pays for it, if it increases the value of the property, the other one can be paying for it through an increase in property taxes and things like that. So you want to create, again, just like we were saying, the system for the use, the system for defining who's paying what in expenses, because money has a tendency to make families butt heads, even when it's unintended.
I think it's important as well to understand what the result or consequence is of not complying with certain requirements. That has created problems within families that co-own property too, that there's somebody that suddenly moves into the property and is using it as their residence. Well, what do you do about that? Is there anything that you can do about it if you don't have any document in place that's defining how the property is to be allocated among multiple people? There might not be something that you can just readily use to deal with that. Or if somebody doesn't have the financial means and just refuses to participate financially, that they continue to be an owner, but maybe they don't like what the holiday schedule is for that year. So they say, fine, I'm just not going to pay for anything because I don't get to use it the way that I want. So what do you do about that? How do you deal with a person that has maybe stopped participating? Or I've also had a situation with a family where there was an owner that couldn't afford to maintain this property. They just couldn't. As much as they wanted to and as much as they appreciated the property itself, it just wasn't something financially they could afford. There wasn't any amount that was funded to the property upon the passing of the owner. So there weren't resources available for the other owners to use. And so the person that couldn't participate financially stopped going there and stopped using it because they didn't feel like they had a right to, and kind of out of guilt. And I think they felt bad about their inability to participate financially. And you can have mechanisms in place. So maybe rather than it being financial contributions that they're making, perhaps each year there's a certain amount of ownership that goes to the other owners because somebody isn't contributing financially. Then they're still giving something up and the others are getting something as a result of it. So everybody still feels free to equally use it. I mean, again, you want this to bring your loved ones together and make them feel like they're continuing to share something among them. You want that to actually happen regardless of their individual financial circumstances or resources, but make sure that that's still fair to the other ones that can.
And yeah, and rules are only effective if there's consequences. Otherwise, they're not really rules at all, because if it doesn't make any difference to somebody, then and they're free to break those rules. Mm-hmm. So yeah, having, again, the system in place for it is absolutely critical. So there's a number of different options. We've been talking about a lot of the considerations. What do we need to think about when it comes to making sure that the planning makes sense and works for the family. But how does this actually function then? There's numerous ways to pass on property. You can have terms in your will that say who's going to get something. And wills, by the way, as a reminder, are sets of instructions to the probate court. That's how those work.
As a reminder, if you've participated in our earlier classes, earlier sessions.
And actually, I should probably mention that, again, if you have questions, feel free to use the Q&A chat box, because any questions that we get, we're going to address at the end of the session here. Okay, so back to the mechanisms for passing property. So there's wills. Then you can bypass probate by using something called a transfer on death deed. Now, you can basically say on a deed, it acts kind of like a beneficiary designation. Hey, where does this go when I die? And the benefit of that is, boy, it'll avoid probate, but you can't do any of the system creation that we're talking about here. There's no way to use the TOD deed to create the who's going to manage this, how we're going to select weekends.
The set of rules that you're going to use. So the transfer on death designation is basically a transfer, just a direct transfer of ownership to these other individuals that avoids the probate process.
Which can be particularly problematic if there's
multiple owners.
Yeah, 6 kids. Oh, this avoided probate, great. But now we have 6 kids who own it as tenants in common, and that can end up being pretty sticky.
Well, especially if it's likely that this property is going to be sold. Because if you have something where you have all these owners on, and especially if they're not local, everything you do with this property now, you have to have 6 signatures potentially that are being put on a document. So that creates some logistical difficulties for the people that are trying to do that.
Well, and we're back to too many chefs in the kitchen. So this is actually a great example. If the decision was, boy, they're not going to want to all own it together, let's just, let them sell it after I die. If it's TOD deeded to those people and you got these 6 owners, all 6 people have to agree on everything, including the sale price. And boy, I've seen that one.
Create some difficulty.
Cause some trouble. Okay.
So we've talked about passing through a will and creating some structure using your will. The downside of that would be the fact that a will does go through probate. So the property would also have to go through probate. Using a transfer on death designation on your deed, which is a direct transfer of ownership. It avoids probate, and that's a good thing. The downside is that it is just a transfer of ownership, that you're not able to create any sort of structure to be able to continue to operate this property with a group of people in terms of decision making and expenses and whatnot, but it does avoid the probate process. So do we have something that does maybe both of those things, where we can avoid probate and still have the ability to create that structure?
Sure. There's a couple of good tools. One is a trust. A trust is a legal agreement where you can you can define how things are going to get managed during your lifetime, who your beneficiaries would be upon your death, and how those things are to get managed both during your lifetime and after your death. So there can be some uses for trusts. There's both revocable trusts and irrevocable trusts. Revocable trusts are great tools for passing assets without probate and setting agreements and rules on how things function. Revocable trusts, however, would not protect that up north property from, for instance, nursing home costs if you were to go into the nursing home. Because what I found is a lot of people's priority is, boy, if I end up needing care, we're going to lose the family cabin, because that piece of property is treated basically just like it was cash sitting in a bank account when it comes to nursing home expenses, meaning there's no special exemption or anything for owning it. Doesn't matter that it's been in your family for 100 years, you're expected to liquidate it for those nursing home costs. So there can be some use for irrevocable trusts in that, and some tax reasons to be doing that, because as an example, I've run into other situations. In fact, I'm dealing with one this week where the family cabin gets transferred to the kids ahead of time, meaning, boy, in advance of ever needing a nursing home, we're concerned about these costs, so we'll transfer it to the kids to make sure that it doesn't get eaten up by nursing home expenses. Well, the problem with that is they've transferred a property that they've owned for many years, and their cost basis in that property is very low, meaning their original, what they've put in terms of money, but the value is much higher. And so when you transfer it to the kids because you're worried about the nursing home, that basically is really bad capital gains tax planning, because when you pass away, if the kids sell it at any point, whether it's many years after your death or the day after you transfer it to them, they end up paying capital gains taxes on the whole difference between your purchase price and today's value. And so that can be tens of thousands of dollars worth of tax. And so that's one of the biggest reasons people might be using trusts to protect the family cabin or cottage, to make sure that it isn't eaten up by something like a long-term care expense.
But they still get the basis adjustment after passing. So they don't have to give up that tax planning benefit in order to get the protection. Doing direct transfers of ownership during life, if you're just gifting the cabin to your beneficiaries prior to any need for care, you're giving up some of those tax benefits. So by using certain kinds of irrevocable trust-based planning, you're able to preserve the tax planning and also preserve the asset over time. So trusts can be a very good tool for setting the terms for how something is going to be passed on. But after they've passed it on and the owners are continuing to own this together, trust doesn't necessarily do as good of a job to continue maintaining a good structure for them over a period of time that they're owning it as a group. That's really where you can use an LLC, a limited liability company, to own a piece of property or pass on a piece of property. You set this up as the owner now, and then you pass on the ownership in that LLC when you pass away to your beneficiaries or to your children. That LLC can have things in there like you can only pass on the interest to another family member. They have to be a blood relative, like you can't leave it to a spouse or something like that if that's a priority for the family. Or this is how we're going to make decisions about expenses. This is how we're going to split taxes. For some families, they have property that they're renting out, that it's actually income producing property. It's not property that they're just using among themselves. So then how are they splitting up some of this income? How are you dealing with income taxes related to this? What expenses are coming out of it? Things that you really need to be able to address in order to successfully own a piece of property ongoing. Mm-hmm. So a trust is a really good tool to pass the interest initially outside of probate, but an LLC coupled with that trust gives you the ability to create the structure to continue to own this as a group and have at least the initial set of rules for how decisions are going to be made. You don't have to lay out all sorts of rules that that some people refer to as like ruling from the grave kind of thing. But being able to give them a structure so they can make decisions amongst themselves that don't create any kind of unnecessary friction, that's really where an LLC can be especially helpful.
And both trusts and LLCs, a lot of times when there is a difference in, the financial abilities of the different people who might be using this property, or frankly, even if there isn't, it can be a really good idea if you want this thing to be ongoing and people just are able to use it and not worry about it. You use one of these, either an LLC or a trust, and endow the property, meaning leaving it cash so that the property can function on its own and there aren't the arguments between the kids about, well, should we pay to put in a boat dock? I can't afford this, you can afford this. They have an ongoing pool of money so that it's really a matter of, okay, let's use this because we love coming here, not how in the heck are we going to afford this?
Right. And you can also name a person to be a manager. So it doesn't require the signatures of everybody participating. You can have one person signing most of the regular day-to-day kind of things with it. So it really cuts down on some of the logistical difficulties that people experience when there are multiple owners. So those two tools used together really provide the best ability for you to give them structure, give them a way to continue managing this property without creating any sort of difficulty in how it's getting passed on later.
Okay, so we have a number of questions that we want to try and address. So one of them is, can you discuss what probate is time-wise and the cost of going through probate? If I have a cottage for $350,000, what's the approximate cost to probate that alone, and how long would it take to go through that process? Okay, so that's actually a tougher question than it seems on its front, because the timetable and cost is pretty variable. It would be actually pretty odd for just a cottage to be going through a probate alone. I mean, not that it couldn't happen, but one of the challenges ends up being, well, how do we maintain this property while it goes through the probate? If the taxes are due and there's no cash in the estate that's going through probate, how is that sort of stuff getting paid? So that can cause problems. It would depend, the length of time would depend a little bit on, are we looking to be selling this property or just transfer it out to one or more beneficiaries? So, the time and costs are pretty variable. If it was just that property, and it was just going down to the beneficiaries,
I mean, probate
probably 3 or 4 months, because there's certain things that you can't avoid in the probate process, like the creditor notices and the period of time for publication and things like that. So you can't expedite it much more than that. But
6 months would probably be a little bit more reasonable when it comes to the minimum time to get something like that through probate. On average, probate takes a year for a lot of estates to get through that process.
Yeah. But in a case of just this one property, and if it wasn't getting sold, other than doing the income taxes for the decedent, it's hard to say. And then in terms of cost, that's pretty variable also. On average, like the national average for this kind of thing is 3 to 5% of the amount of assets that are going through probate. So you can take that with a grain of salt. That doesn't necessarily apply to this situation, but it's on average what it's going to cost.
That's also one of the difficulties with how this is getting passed. If that's the only thing in probate, where is that money coming from to pay the court fee associated with it? So
yeah, because there's court fees and other things. So yeah, those are all challenges. Okay, we got another question. How do I know what type of document is for me? We have a second generation property passed through my parents. Me and my siblings all have kids. Not sure what the next steps would be or how to get the property to the next generation. Well, since the property is already passed on to multiple people, since you said my siblings, I'm going to guess there's at least 3 of you. You guys, at this point, you all have to work together for this to be successful.
Usually I start this process when it's clients of mine that I'm working with by doing a family meeting where we bring in all of the current owners, have them participate electronically depending on where they're located, and have at least that initial conversation of what does everybody want to do with this? Is there one particular side of the family that really wants to keep it? Do you want to limit how many people an individual can leave it to? I mean, that ends up being one of the common problems with passing it from one generation to the next. If everybody leaves it equally to all of their children, you can go from 2 owners in a couple of generations to
20
or more.
Yeah.
So there are some pretty extreme examples of this.
Yep. And then you got a 125th owner who lives in Seattle, and they see the property as nothing but a tax burden, and they never use it, and they're never coming back, and it can get a little sticky.
It can also then impact your ownership interest in terms of what that value means. If there's one family that passes it to multiple generations a couple times, and the other side where it's just one child each generation, that one child is going to end up with a larger percentage than maybe the other percentages that have been divided among multiple people. So it's good to figure out as early in that process as possible. If you wait until your generation starts passing and it goes down to your children, it's going to be even more people that have to come together and agree on a set of terms. So, you always want to try to do it or address it when it's the easiest way to do so. So I would start with a family meeting and really talk through what are the expectations for this? What do people want to do with it? Do we have people that want to get out of it? So is it more of a buyout process? That really sets the table for everyone.
Yeah. Start with what do you hey everybody, what do you co-owners, what do you want? And then once you have an understanding of that, at that point, it'd be time to involve an estate planning attorney and do a family meeting.
Mm-hmm.
about how this is going to work.
It can help with the conversation to have the ability to get questions answered during that conversation, so everybody feels like they're making informed decisions about what they want.
Is there a way I can leave money for my kid who isn't good with money that they can only use for their share of the cabin? Yeah, absolutely. I don't know if that question was sent before or after we started describing things like the LLCs and the restricted use and the trusts, but one of those two or a combination of them actually can absolutely make sure that you're providing for the property and not allowing the child themselves to squander it in things that you wouldn't have wanted.
Those tools can also be used to help deal with liabilities that one of the owners might have, to try to protect the property from being subject to creditor issues of one of the other owners. So you can sometimes create protection both ways to ensure that other owners are not going to be impacted by financial difficulties of one of them.
Okay. And then last couple of things, is there a presentation where we talk about these types of documents with purpose, benefits, watchouts? So, I mean, obviously for family cabins alone, that was hopefully you got some sense of, what different documents you might be using and pitfalls and problems.
The handouts that are part of this presentation are also partly for that purpose, where we have information about what these different tools are, what they mean, what types of differences are there among them. So that is a piece of this as well.
But this is an ongoing series of different seminars, which, by the way, our next one is going to be Wednesday, June 3rd at noon.
But the topic for that one will be, what do I need to know about parents or loved ones that are likely transitioning to a need for care at this point? So from the perspective of the caregiver. Yep.
And so that's, again, Wednesday, June 3rd at noon will be. So there's different topics in this series. Most of them, if not all of them, are posted to our Facebook page. And are they on our website as well?
I don't know, honestly.
I'm not sure either, but they're definitely on our Facebook page. So you might peruse the different topics there. So these are and I just got a message that they are on our website. So you can peruse those videos. Maybe there's a topic that you see there that you think is on point. There are some more, I guess, 101 kind of what's a will, what's a trust, how do powers of attorneys work.
We do have
things like that.
We do have a page on our website as well, specifically about planning for up north property, where it provides some of these things.
Mm-hmm.
But the presentation today with some of the handouts on our website and some of the other videos, I think should give you at least a good idea on what you need to know in order to figure out what path should we really be going down.
Yeah. So hopefully everybody found this to be a useful way to spend some time. We appreciate it, your participation. Obviously, the topic is at least relatively important to you because it's a beautiful day, and instead you're choosing to listen to us. So, thank you very much for your time. If you have, follow-up things, if we talked about stuff that you think is really important to you or your family, and you need to follow up with an attorney, you can feel free to contact us. Either by web or by phone. And
our initial consultations are free of charge. Right now, we're doing all of our initial consultations either by video or by phone, so that we're keeping everybody's health and safety in mind. So please feel free to call. We can get you scheduled if you have any specific questions that you'd like to get answered on this topic or on other topics associated with estate planning.
Yep. So thanks for your time, and you guys all have a fantastic day.
Bye, everyone.